Asset protection in Australia is about planning well before financial difficulties arise, because once bankruptcy becomes a real possibility, many transactions intended to protect assets may instead be investigated and reversed by a bankruptcy trustee. One of the most common misconceptions is that assets can simply be transferred to a spouse, family trust, company, or other family member shortly before bankruptcy to place them beyond the reach of creditors. In reality, the Bankruptcy Act gives trustees extensive powers to investigate pre-bankruptcy transactions and recover property where the statutory requirements are met. Whether a transfer is effective often depends on factors such as its timing, the value paid for the asset, the financial position of the transferor, and the purpose behind the transaction. Not every asset automatically becomes available to creditors. Certain categories of property may be protected under the legislation, including qualifying superannuation interests, ordinary household goods, personal effects, tools of the trade, up to the applicable statutory limit, and certain motor vehicles. However, these exemptions are technical and subject to strict legal requirements. Simply assuming an asset is protected because it is held in a trust, company, or other person's name can lead to costly mistakes if the legal ownership and surrounding circumstances do not support that conclusion. Lawful asset protection focuses on legitimate long-term planning rather than reacting to financial distress. Appropriate business structures, discretionary trusts, corporate entities, estate planning, and carefully considered ownership arrangements may all have a role in managing commercial risk. However, these strategies are generally most effective when implemented well before the insolvency becomes foreseeable. Once creditor pressure, litigation, or financial distress has emerged, transfers of property are far more likely to be scrutinized by a bankruptcy trustee and, in some circumstances, set aside by the court. Other important point is that bankruptcy and company law are separate legal regimes. A company's assets do not automatically become the personal assets of the bankrupt director or shareholder, but shares personally owned by the bankrupt individual may vest in the bankruptcy trustee. Likewise, personal guarantees, recoverable transactions, and statutory director liabilities can still expose individuals to significant financial risk despite operating through a company structure. Ultimately, effective asset protection is not about hiding assets or transferring them at the last minute. It's about understanding how Australian bankruptcy law distinguishes between legitimate financial planning and transactions that unfairly prejudice creditors. Obtaining advice before financial difficulties arise often provides the greatest opportunity to preserve wealth lawfully, whereas waiting until bankruptcy becomes imminent may significantly limit the options available and increase the risk that carefully planned transactions will ultimately be unwound by a bankruptcy trustee. Contact us today for a free 30-minute consultation with one of our experienced team of insolvency professionals and let us help you protect your rights.